We are live. Good evening, everyone. I extend your warm welcome to our today's webinar on the topic income under the head salaries under the Income Tax Act 2025, and also on the topic how to improve efficiency in the assessment by Dr. Rakesh Gupta sir and by Dr. Raj K. Agarwal sir. Today's deliberation, over to you, sir.
Yes, first of all, I request Dr. Raj uh, to give an overview of the topics today so that thereafter I will take the thread.
We have taken this initiative to have a periodical discussion on interesting issues which are prevailing relating to income tax, and particularly in view of the Income Tax Act 2025, which has been recently introduced. Though there are not any substantive amendments which have been made in the Income Tax Act 2025, all the provisions of this act are almost on the same lines as were in the old act. Only the language has been changed, and the sections, provisions, provisos, etc., have been rephrased in a simple and lucid manner. However, we will discuss all the chapters relating to Income Tax Act 2025. So, if there are any major amendments or substantive amendments which are emerging due to change in language or which may create some new litigation, we will try to highlight those issues. Apart from this, in today's topic, we are taking the topic of the assessment, that how, what are the intricacies of making representation in the assessments, and Dr. Rakesh Gupta will discuss in detail this topic, keeping in view certain interesting issues. So now I hand over the mic to Dr. Rakesh Gupta.
Thank you, Dr. Raj. It is after a considerable time that we are back. And as Dr. Raj has explained, that Income Tax Act 2025 now is coming into effect from 1st of April 2026. So we have thought that we will pick up certain sections, certain chapters, and quickly traverse through so that we may find as to whether there is any change uh, in 2025 Act relating to those provisions as compared to 1961 Act. So today we have thought that we will pick up income under the head salaries, that is section 15 to 19 of 2025 Act. So as Raji has brought out, that there is no conceptual difference between Income Tax Act 1961 and Income Tax Act 2025, except that there are no provisos, there are no explanations, and there are no non-obstante clause in the form of notwithstanding. That notwithstanding, non-obstante has been replaced by irrespective of. Uh, there is nothing substantial change in the topic of income under the head salaries, except certain things which have been brought under section 19 by picking from erstwhile section 10. And so now section 15, earlier also in 1961 Act, the section was section 15 only, now which tells about which income shall be included chargeable to income tax under that salary. So any salary due or received by an employee from the employer or from the former employer, or advance salary or arrears of salary, if it has not been charged to tax earlier, now that will form part of income chargeable to tax under the head salaries. So section 15 is only to this extent to tell us as to, and so it is on almost identically worded under section erstwhile section 15 of 1961 Act, except that provisos have also become subsections. The explanations given under old section 15 have become. Then 16, section 16 in 1961 Act used to speak about the deductions which were admissible under the head salaries. If you remember, standard deduction, entertainment allowance, professional tax. I mean, those deductions used to come in section 16, but now those deductions has been uh, now shifted to section 19, apart from other deductions to which we will make a reference little later. Now, section 16 of 2025 Act now says that salary includes what? Salary. So, if you remember, under the old 1961 Act, section 17 contained three portions, A, B, C. 17 that used to define as to salary would include what, then perquisite would include what, and then profits in lieu of salary would include what. Now all those three things now have been bifurcated under separate sections in 2025 Act. So section 16 says that a salary would include what, and it is almost the same kind of items which were there under section 17 earlier. Similarly, for perquisites also, uh, all those perquisites which were there under 1961 Act, except that they have been shifted from erstwhile section 17 to newly incarnated section 17. Then third is profits in lieu of salary. Profits in lieu of salary in 1961 Act used to be under section 17 itself, but now section 18 of 2025 Act tells as to profits in lieu of salary would include what. So these three things, salary, perquisites, and profits in lieu of salary, as were there in 1961 Act, in section 17 then now have appeared now in section 17, 16, 17, and 18. Apart from that, there is no substantive change. Now, under the new Act, 2025 Act, there is section 19, which speaks of deductions from salaries, which was there earlier, as I pointed out a little while ago, under section 16. Now, this is also the same in as much as standard deduction now is under section 19 instead of section 16 earlier. And then all those deductions and exemptions which used to be there under section 10, like death cum retirement gratuity, other gratuity received under the Payment of Gratuity Act 1972, then leave encashment or any other gratuity, payment in commutation of pension. So all those exemptions which were available to the salaried class, now instead of section 10 earlier, now they have been brought under section 19 of 2025 Act. So there is no substantive change except this kind of change. Now otherwise, except for the placement of certain items from erstwhile section 10 to now new section 19, there is no change. There is no change in absolute limit. There is no change in the conditionalities which were attached in erstwhile section 10 in the matter of exemptions. Now, but then it will be called now deductions. Earlier, if you remember, under section 10 used to come in chapter 3 that following incomes or incomes mentioned in chapter 3 would not form part of total income. Now, these exemptions which were there in erstwhile section 10 of 1961 Act would be called deductions under section 19 of 2025 Act. Now, what will be the implications of that? Now, that needs to be analyzed. The one thing which comes to my mind is that those exemptions under section 10, erstwhile section 10, would never form part of the total income, whereas these deductions under section 19 would be allowed as a deduction from the gross salary under 2025 Act. So whatever consequences will be there in order to treat erstwhile exemptions to now deductions, and that will follow. But then there does not seem to be any major impact or consequence as a result of reclassification of erstwhile exemptions to now deductions. So with this brief background of the salary chapter, whereby the provisions of salaries now have been spanned on 5 sections, 15, 16, 17, 18, and 19, as against the earlier three sections 15, 16, 17 of 1961 Act. Substantive, there is not substantial changes, and therefore we can shift to another topic of today's deliberations. Uh, so, in this manner, we plan to traverse through the provisions of the 2025 Act so that at any point of time thereafter, we should not feel that we have not gone through the Income Tax Act 2025. So, the second topic which has been kept for today's deliberation is how to improve efficiency in the assessment. Now, how to improve efficiency in the assessment is not written anywhere. It depends upon the practice, it depends upon the experience which one derives. And this topic has been developed or evolved by us based upon our experiences in litigation. Because we find that certain deficiencies which are left unattended by us while representing the cases of our clients, or certain points which are not kept in mind while representing the cases before the assessing officers in respect of our clients' cases, uh, how to remove or how to remove those irritants, how to remove those things, so that a different level of efficiency comes in the assessment proceeding. So let us begin as to what factors should be kept in mind while representing the cases of our clients during assessment. So, the first and foremost thing which comes to my mind is that factual pleadings, averments, and evidences in respect of an issue for which the questions have been asked by the assessing officer. Now, that must be placed during the course of assessment before the assessing officer. So, the factual pleadings or the factual evidences or the factual averments in respect of any issue. So, if an assessing officer has asked us justify the commission paid, so we must give not only the details of commissions paid, but then to whom it has been paid, what is the address of the person to whom the commission has been paid, how much is the commission, what is the mode of payment, what is the copy of account, what services have been rendered by him in consideration of which this commission has been paid, what are the evidences in order to show that that person has performed a particular task in consideration of which we have given this commission. So once an assessing officer asks, his duty is over, then the ball is in our court. And we have not to wait that the assessing officer would again put his question. So we must ensure that before the assessment proceeding is concluded, the factual pleading, factual averments, factual evidences in respect of the issues asked are placed in the file. And we have to be aware about the burden of proof, the law of burden of proof, because unless we make ourselves aware about the burden of proof, we would not be in a position to know as to burden lies on whom to prove a particular fact in a particular situation. So, the broad principle of the burden of proof is that when it comes to the question of asking, when it comes to the question of proving the deductions, the exemptions, the relief, the rebate, then the burden is on the shoulders of the assessing. Burden is on the shoulders of the assessing. So if an assessing officer has asked you to justify a particular expense, a particular deduction, a particular rebate, or particular relief, since SSE is claiming the benefit of those deductions, exemptions, rebate, or relief, the burden is cast on his shoulders. Therefore, he should come forward to discharge that burden by leading or by pleading on facts and by leading the factual evidences on record. When it comes to the question of taxing the income or taxing the receipt as income, then in most of the cases, the burden is on the shoulders of the assessing officer, except in certain situations where this burden has been put reverse on the shoulders of the SSE. So, if it comes to the taxing of, say, certain liabilities which have ceased to exist, the burden to prove that liabilities have ceased to exist, now it is on the shoulders of the assessing officer. When it comes to making disallowance out of an expense, then the burden to prove that this fits into the scheme of a particular provision of law, and for this reason it fits into that scheme of making disallowance, that burden rests on the shoulders of the assessing officer. So if an assessee has made payment under section 40A3 in cash, the burden is on the assessing officer to prove that this has been section mandate of section 43 has been violated. If the tax uh, which has been deducted but not paid, or which has not been even deducted, then the disallowance has to be made. So under section 40 or under section 40 capital A, there are various disallowances. So when it comes to the question of availing any benefit of deduction, rebate, relief, exemptions, the burden is on the shoulders of the assessee. When it comes to the question of taxing a receipt as income, or when it comes to the question of making disallowance, then the burden is on the shoulders of the assessing officer. Now, one exception which comes to my mind, which I must clarify at this stage, is that cash credits, because section 68 of the 1961 Act, now there are corresponding provisions under 2025 Act also, except the change of name of cash credit. Now that is sought to be made now unexplained credit. Otherwise, the contour of section 68 and now section 102 of 2025 that remain the same. And it says that when any sum is found credited in the books of accounts of an SSE, then the burden to prove its nature and source rests, initial onus to prove its nature and source rests on the shoulders of the SSE. So here I have taken a receipt, and that receipt is sought to be taxed as my income. Now, in ordinary case, the burden should have been on the shoulders of the assessing officer, but then because of a particular provision of law, which is there under section 68 of 1961 Act, so this initial onus or initial burden is on the shoulders of the SSE. Now, when the moment there is any sum found credited in the books of account of an SSE, then it is the SSE who has to come forward by discharging his burden, by showing that yes, here is the identity from whom this receipt has come. This is the capacity of that person from whom that amount, that receipt has come, and the creditworthiness or the genuineness of the transaction, that this transaction is genuine, and these three ingredients are required to be initially proved by the SSE. Only then that burden will shift on the shoulders of the assessing officer. So this law of burden of proof now is essential to be understood so that the burden can be discharged. Now, so the first and foremost principle which I explained a little while ago is that factual pleadings, factual evidences, factual averments, that must be placed before the assessing officer by the SSE. Law, of course, can wait. Even if I have not put my legal pleadings before the assessing officer, I am not precluded, I am not ousted from raising those legal pleadings before the appellate authority. Now, my way cannot be stopped by the revenue or by any officer by saying, since you did not plead this law, you did not bring it to the notice of the assessing officer, and therefore you should not, or you cannot plead it before the appellate authority. No, that is not the correct law of understanding. Yesterday, I was in the tribunal, and SSE was explaining a situation whereby the board notification came extending the date of filing of return. And assessing officer disallowed the carry forward of the loss on the ground that the return was filed belatedly. It was the case of the SSE before the tribunal. So this date was extended. I remember the learned DR sought to raise an argument before the tribunal, which however was repelled. That, sir, this has been raised for the first time before the tribunal. It was never brought to the notice of the assessing officer. Now, this position of law, whether the date has been extended or not, now it is supposed to be known. And whether I did not bring it to the notice of the assessing officer, and if I have taken this plea before the appellate authority, then nothing obstructs my way to raise these legal pleadings or legal arguments before the appellate authority. But then, position of law is not like this in case of the factual pleadings and factual averments. Because if you do not bring factual pleadings, factual averment, factual evidences before the assessing officer, then Rule 46A of the Income Tax Rules 1962, and there will be corresponding rules under the new act also, which would say or which say that no additional oral or documentary evidences can be produced by an assessee which were not produced before the assessing officer. So these kind of evidences which were not filed before the assessing officer during the course of assessment, they are called additional evidences technically. So these additional evidences, I'm not saying that they cannot be filed. They can be filed, but there are serious handicaps. And the handicaps are that you will have to seek permission of the appellate authority that these are the evidences which could not be filed during the course of assessment proceedings and because of this reason. And those reasons are given in Rule 46A. So you have to make out your case within those four situations which are prescribed under Rule 46A, that you wanted to give it to the assessing officer, but then the assessing officer refused to admit that evidence. Or you were prevented by sufficient cause from producing it before assessing officer, though you were called upon to produce it before the assessing officer. Or you were prevented by sufficient cause from producing an evidence which is relevant to the ground of which is relevant to the ground of addition. Or when the assessment order has been passed without giving you adequate opportunity being heard in relation to any addition which is made against you. So you will have to seek permission from the appellate authority by making out your case based upon one or more these four situations which are given under Rule 46A. Only then the appellate authority, and that too appellate authority is required under the law to give opportunity to the assessing officer that here are the additional evidences furnished by an assessee claiming under a particular clause of Rule 46A. Now what do you want to say? So it will be for the assessing officer to put forth his opposition as to the admission, and after taking into account the objections of the assessing officer, only then the first appellate authority would have to pass an order to admit or not to admit those evidences. So an evidence which you as a matter of right could have got it admitted by filing it during the course of assessor proceeding, now you are within the realm of judicial discretion of the appellate authority. So this should be avoided, because I have seen many good cases lost for the reason that evidences were not filed during the course of assessment. And when the additional evidences were sought to be filed before the appellate authority, then the case was not made out under any of those four clauses of Rule 46A, and those evidences were not admitted. The effect of those evidences were not taken into consideration by the appellate authority, and then even a legitimate, a good case, I have seen SSEs losing. So I always say that the law can wait, but the factual evidences, factual pleadings, factual averments, they should not be made to wait, because if they are made to wait, then maybe it may be very expensive, costly, and very, very expensive wait. So additional evidences should be avoided to the extent possible. But I am not saying, nobody should misunderstand me to be suggesting as if additional evidences can never be filed. No, it can be filed. But then the practical difficulties, which an SSE faces because of the evidence's nature being additional, that SSE will have to overcome one more hurdle, and that hurdle is not a simple hurdle. So one should be vigilant. Yes, of course, if an assessing officer decides an issue without giving you an opportunity of hearing, then obviously you do not have any option but to uh, file additional evidence. Then we should not think that let assessing officer ask it again. No, once he has asked by issue of notice under section 142(1) or earlier on through order sheet entries, then his duty is over. Then the ball is in your court. Now you cannot be heard saying, now if he had asked you once more, then you would have given, and therefore you were prevented by sufficient cause. No, his duty is over. Once he has asked, his duty is over. Therefore, this has to be kept in mind. So, in the matter of cash credits, in the matter of commission, in the matters of expenses, in the matters of deductions, exemptions, creditors account, I mean, you have to make, like in creditors cases. So, if the balances are outstanding, and if assessing officer has asked you justify the creditors balances outstanding, then you should be, because the assessments do take place much later after the closure of the year. So, if those payments have been made in subsequent year, so the copy of account of that party showing that subsequent payment, now that should be brought on record. The copies of your bank statement showing the payments outflowing from the bank account, that bank statement should be placed. So what you have to do is that you have to envisage, you have to comprehend, you have to visualize as to which evidences would strengthen your cases. That you'll have to think, you'll have to visualize, and then bring all those factual pleadings and evidences on record. Because I always say that each piece of evidence which you furnish during the course of assessment proceeding, that goes a long way in uh, uh, cementing the case, foolproof case for you. Many times I have seen, and so must have you also, that assessing officer uh, asks during the course of assessment proceeding, referring to certain statements of some witnesses. Those witnesses may be your employees, your witnesses may be some outsiders, your customers, your suppliers, or somebody outside. But then assessing officer alleges that they have said something which goes against you. So the first and foremost thing which should be there whenever such kind of a statement is sought to be pitted against you in some notice, in some way, then, sir, where is the copy of that statement? Kindly that statement be supplied. And after you get the copy of that statement, then your request for cross-examination that person, because I am talking of a witness who has spoken adversely against you. So if he has made some adverse deposition against you, then you should be demanding cross-examination. Cross-examination is a very, very valuable right, because if the department has recorded a statement, maybe at your back, but department has supplied you that statement and you choose not to ask for cross-examination, then the presumption of law would be that his statement before the statutory authorities now will carry evidentiary value. Its evidentiary value is there, but then the credibility of that witness has to be tested on the touchstone and barometer of cross-examination. And cross-examination, though is your right, but then it must be demanded. In case it is not demanded, then your right to cross-examine may be lost. And then, if before the appellate authority you want to say that you should be allowed cross-examination, the appellate authority would say, why did you not ask it before the assessing officer? So, whenever an adverse deposition is referred, either in the reason, either in the information suggesting escapement of income, either in the form of any order sheet entry or in the form of any entry in the notice under section 142(1), this copy must be demanded, and then cross-examination must be demanded. Many times, in case of search or survey, assessing officer refers to various documents and then asks for explanations. Now, many times those documents may not be speaking documents, they may be dumb documents. So, in such a situation, your reply now will go a long way in department deciphering the document. So, your reply at this stage is very important. Now, situations cannot be, and all situations cannot be envisaged at this stage, except to say that if a document is dumb, then how to give tongue or not to give tongue now is a decision which has to be taken, at the end of the SSE. Many times some adverse material is also referred by the assessing officer. Adverse material may be in the form of some document found from somebody else's place. Now he extracts a portion of the document or portion of a statement, adverse statement also in the notice under section 142(1). In that situation, my humble suggestion would be that you go in for asking for the whole of the document or whole of the statement, because if you see or if you read the complete document or complete statement, then the reference and context, correct reference and context in which a particular document or particular portion of a document, would show, or particular statement would show, that would be clear when the complete statement or complete document is in your possession. So therefore, if an assessing officer tries to extract only a portion in the notice, you demand for the full copy of the statement and the document. That must be uh, if there are certain witnesses now whom you think that if they appear before assessing officer and can give uh, valuable evidence in your favor, then you can always, and that witness may not be forthcoming at your request, then you have got power under the law to make a request to the assessing officer to exercise his powers under section, whatever powers he has got under section 131 now under the new act and the corresponding provision. Sir, you exercise your power to enforce the attendance of that person who is a witness, and if assessing officer chooses to sit over your request, or if assessing officer issues notice and he does not turn, then the default or fault cannot be fastened at your door. So this is also an important thing, by which you can, like it so happens in case of the creditors, it so happens in case of the trade creditors. Now you have made payment, suppose you have made payment, then why should a trade creditor take any interest in your request to appear? Or if suppose there is some creditor now with whom you have developed some animosity or quarrel, you may not be servicing his debt, you may not be paying, you may not be paying him interest as agreed upon. So necessary cooperation may not be coming from that witness, from trade creditor, from the unsecured lender. So in that situation, you may request the assessing officer to enforce the attendance of that person. And if an assessing officer does not accede to your request, then the very fact that we have made request to the assessing officer to exercise his powers to summon has not been exercised by him will go in your favor. There are always a question, as I said, the legal pleadings can wait, but then there are a couple of legal pleadings which cannot wait, because there is a statutory edict and mandate under the act itself that unless these legal pleadings or unless these pleadings are raised before the assessing officer before the conclusion of assessment proceeding, then or within a particular time frame, then you are precluded from raising them before the appellate authority. Now one section which comes to my mind is section 292BB. 292BB, it says that in case you participate in any proceeding before an assessing officer, then later on you cannot be heard saying that the notice has not been served on you. So if you want to, you can appear before assessing officer, but then you can always bring it on record that particular notice has not been served. So only then your defense to argue it before the appellate authority remains. But then if a particular notice has not been issued, then the non-issuance of notice can always be pleaded even if you have not raised this issue before. So there is a difference between the non-issuance of a notice and the non-service of a notice. The notice having been issued, not served, will have to be agitated by an SSE before the assessing officer before the conclusion. But then non-issuance of notice, issue if notice has not been issued, like in case of 143(2) earlier, the notice at times, was not issued within the time, and then SSC wanted to urge it before the appellate authority, the department would always argue that this issue was not raised before the assessing officer. The matter went up to the stage of the Supreme Court. The Supreme Court said the 292BB cures the non-service, not the non-issuance. So, 292BB uh, is a section which requires an SSE to put his objections before the conclusion of assessment proceeding, unless, of course, that assessment is made under Section 144, that a particular notice has not been served. And the second mandate of law is Section 124, subsection 3, that if an assessing officer who does not enjoy the territorial jurisdiction, nowadays, now this has become blurred because most of the cases are in faceless regime, but whenever, because but wherever the territorial jurisdiction used to be vested with the different assessing officers, and you receive a notice from a different assessing officers other than the one who wields jurisdiction, then says that you were required to raise the issue of absence of territorial jurisdiction within a particular time frame given under Section 124(3). And that time frame used to be very narrow window of 30 days from the date of service of notice under Section 143(2). So, if that is not objected to by you under Section 124(3) within this time frame, then the law says that then you you would have been precluded from raising the issue of absence of territorial jurisdiction before the appellate authority. So, now there may be certain situations where certain facts cannot be proved with the help of evidences because the evidences are not available. When I say evidences are not available, the documentary evidences may not be available. There may be several situations with respect to this aspect. Suppose, for example, you have to justify the existence of agricultural income out of which you have met out your household expenses. There may be other situations also. So, certain facts which cannot be proved with the help of documentary evidences, then the duly sworn affidavit constitutes an important piece of evidence. So, in such a situation, when you cannot prove a particular fact, like in case of jewelry having been acquired by you from your ancestors or from your grandparents or from your parents. So, in such a situation, because there is no evidence for that except the circumstantial evidence, like in case of agricultural income out of which you have met your household expenses. Now, there is no evidence of agricultural produce, but the fact that you have got agricultural field with you on which operations are on, then you can state all those facts by way of an affidavit. Affidavit ostensibly appears to be a self-generated or self-made evidence, self-serving evidence, but it is not like this. The law envisages the affidavits in a particular importance, and it carries very important uh, consequence also in case it is found that the averments or the depositions made on that affidavit were false. Because there is a section under the Criminal Procedure Code, I mean, it says that falsity in any affidavit is liable to be prosecuted for perjury. So, a deponent who states something on oath in the Solomon affirmations, now he must remember that the factual averments which he makes in that affidavit are correct to the best of his knowledge and belief, and nothing is concealed or misstated therein. So, affidavit at times can be made use of, uh, can be made use of for bringing out certain factual averments which otherwise cannot be proved with the help of. I remember some commission was paid to an agent for the purpose of making follow up of the payments, and for which he used to be paid a remuneration. Now, when it came to prove the services rendered by him, apart from the averment which we made by way of the factual pleadings, now an affidavit was sworn by that person who was the agent who used to make follow up for the payment. Now he detailed out all the facts and circumstances and his role of following up those parties for seeking the payments. And then, because there is no evidence, then if there is no evidence coming, then the evidence by way of duly sworn affidavit detailing the facts, which should be correct, of course. Now that is better. That situation is better. So this similarly in case of penalty. Now penalty is not to be imposed when there are a reasonable cause, because if you remember that under the Income Tax Act there are several defaults which have been envisaged, and for each default there is a penalty. But then there is a defense mechanism also under the Income Tax Act which says that penalty shall not be imposed if an assessee comes forward and explains that there was a reasonable cause for the default. So this defense mechanism expects an assessee to come forward to make out a reasonable cause in case the default admittedly has happened. So, what can be the reasonable cause? It depends upon the facts and circumstances, because it is my experience that nobody commits default for the sake of pleasure. The defaults do happen, and there are always some reason because of the defaults, or there are some reasons because of which the defaults happen. You'll have to find out those. You'll have to find out the reasons of those defaults, and then you have to plead it before the penalty imposing authority that this was the reasonable cause. This was the cause, which is a reasonable cause because of which the default has occurred. So it is also whether there was a reasonable cause or not is a question of fact. And as I said a little while ago, that factual averment, factual pleadings, factual evidence, that must be brought on record. And this burden to bring it on record is on the shoulders of the SSE. Now, this burden is all the more in case of reasonable cause, because it is the SSE who wants to avoid the levy of penalty, and therefore he has to prove that there, and for that he has to prove that there was a reasonable cause, and therefore it is the SSE who will have to come forward. So uh, I always say that in the matter of facts, one has to be very charitable, liberal, and one should not be miser. I have seen many persons not parting with factual evidences, factual pleadings. This is not good because it ultimately impinges upon the efficiency level of the assessment. Ultimately, it has got bearing on the final outcome in appellate proceedings. Many good cases are lost because the evidences are not brought on record. I mean, factual pleadings are not brought on record, and therefore, I would urge that if you want to improve efficiency in the assessment, then these things which I have just narrated briefly, we have thought to keep these sessions not very lengthy, because so these are certain points which I have. There may be other points also, but then whatever points which have come to my mind, I have explained, and you can make use of them in order to bring a better efficiency level in the assessment or assessment or appeal, or in whatever representation which you make. Like in case of the adjournment applications, I have seen the most casually awarded adjournment applications. Now every application is like a petition, I mean, under which you are trying to seek a relief. And I always say that every petition should be drafted in a manner. Suppose if tomorrow it is rejected, then you should be in a position to avail the adequate remedy before the appellate, before either the appellate forum or before the writ court. So your all petitions, be it adjournment applications, be it your penalty replies, be it your uh, stay of demand petitions, they should be so made, like in case of stay of demand. Now you have to make out your prima facie case on merit. You have to make out a prima facie case as to why these additions which have been made in assessment ought not to have been made in the first instance. You have to make out a strong prima facie case. then you have to make, or you have to lead evidences of absence of liquidity at your end. So nothing is as a matter of right. Like even adjournment is not a matter of right. If you are seeking an adjournment, then there must be a plausible reason for it, and if necessary, then that plausible reason should be supported with evidence. Merely making the petitions in a routine, in mechanical manner, now does not advance your interest. So this uh, should be. And now the importance of speaking, the importance of making all these pleadings, so speaking, now assume the larger importance in view of the facelessness of the proceedings, because ultimately earlier there used to be a faceful interaction with the assessing officer. Now it is faceless most of the cases. Therefore, the importance of pleadings, importance of evidence, importance of making various petitions now is very important. And I think if there are issues which can be there, then I would be pleased to answer. So that is all I wanted to share today.
Saksham, are there any questions?
So we have not received any questions as of yet.
Okay.
But
So I think
we did not
uh,
tell also that if somebody wants, they can put the question in the box.
Yes, if somebody there's a chat box down below. If someone has any questions, they can be put in the chat box.
any other thing which you would like me to speak, Saksham?
So I think we have wonderfully covered the topic for the today. Both the
Uh,
topics have been deliberated in detail.
No, but then Income Tax Act 2025 provisions I have discussed very briefly, because there is no substantive changes between the two acts. So a broad scheme, broad sections. What are those sections, so that we may have the first feel of
Yes,
the salary provisions under 2025 Act? That was my motto and objective. So the next deliberations we'll keep income from house property, and then we'll try to make a quick comparison between 1961 Act and 2025 Act. So I think now
we
it's
have
already 50 odd minutes. There are no questions for whatever
we
reasons.
just received one question, sir.
What is that?
So that is on your screen, sir. What
What if jurisdictional issue? What if jurisdictional issue raised before CIT appeal is good or not? No, I mean, I always say that even if our jurisdictional issue is very good before the appellate authority, but then we must make an attack from all rounds. Now, we cannot rest only on the jurisdictional issue. You make arguments on jurisdictional issue, you make arguments even on merit of the additions, and if you have got five weapons in your hands, fire them. Any other?
that is also.
Okay, so
I
let
think
us
we can
conclude it.
conclude.
Uh,
Thank you so much, sir. That was really insightful and informative top deliberation on the both the topics, sir. Thank you for joining us.
Thank you. Thank you.